Super. So we'll just give it a couple of seconds for people to come through. All the people that have joined us this evening, which is good. Just takes a couple of seconds for that to happen. So how are you doing anyway, Ray? Are you good?
I'm good, yeah. I'm at the ASPD annual dinner.
Oh, brilliant.
Well, I'm not at the dinner, I'm in my bedroom, but everyone else has gone for a
So there's a nice
a
dinner
boat
taking
ride
place
around
somewhere.
Bristol Harbour.
Oh, very nice
Um,
indeed.
so what can you see my screen?
No, I can see you at the moment. So
Right. So how do
on
I
the
get
on the
the
navigation bar at the bottom, there should be a share button.
yeah, but there isn't. That's what I'm concerned about. I need to get
So there should be a control panel.
now I've only got
Is it at the top of your screen?
hang
So
on.
where you were able to turn your
Hang on,
video
show
on and off.
presenter view. And show. I've not got screen share on my presentation.
No, it'll be on Zoom.
Yeah, and I don't know how to get back to Zoom now. Hang on. How do I get rid of this?
So
Ah,
while
there
you're
we
just
are.
getting that
There we
sorted,
are.
you got it sorted?
Okay, so where's the share? Yeah, I've got share.
Yeah,
So
so
if I go on this,
if you hit share and then just click on your PowerPoint presentation, it will come up and then you'll be able to start your slides from there.
I don't know what the hell that is.
Oh, there we go. This is looking good. Brilliant. There we go. So if you're just putting that into slideshow mode, then you can click through. There we go. Perfect.
Shall I leave it like that or?
Absolutely perfect. Is that your first slide?
Yeah.
Perfect. Right. Well, what I'll do is I'll just quickly introduce you, Ray, and then I'll put my video and audio on blank, and then people can get the full attention of you. So, thank you everybody for joining us this evening. For those of us that have been here before, you know the format. We have a guest that joins us and talks on that specialist subject. And tonight we've got Ray Goodman, a partner of Acuity Law, joining us, which is Acuity Law even. Which is great. Ray's going to talk about successfully navigating a sale and everything you need to know about the legal process of selling a dental practice. And I think for me in here, there's two things. The first thing is the person who owns a dental practice who's selling, I believe, has the most influence over the timetable of that sale going through, because it's a seller that has to produce all the due diligence documentation to their solicitor. So when you hear people talking about timelines of selling their dental practice, and you hear what's, oh, well, I sold in 4 months or 5 months, or well, mine took 9 or 10 months. Not always, but invariably, it's down to the person who's selling, the speed of getting that information together. It's particularly pertinent in May 2025 because anybody who's thinking of selling and they want to sell before the increase in capital gains tax, which goes from 14 to 18% in April next year, actually doesn't have that long. You've kind of got to crack on with it now. So what Ray's going to talk us through is the legal aspects of the things that need to happen to make sure that if you were looking to sell in next year, that happens. Here we're talking about heads of terms, type of practice structure, how to navigate the due diligence process, exchanging contracts, what happens at completion. Most people only ever go through this once. So getting access to this information now is hugely valuable. So I'll hand over to Ray. Like I say, I'll just blank my video and my audio, so you've got the full attention of Ray, and I'll come back in at the end in the last sort of 10 minutes, and we'll have a question and answer session. If you do have any questions as we go through, just drop them in the box, and we'll pick those up at the end. So over to you, Ray.
Thanks, Andy. Can you hear me okay?
I can, absolutely perfect.
And you can presume, can you see me or just
I can see you in the corner and I can see your slides, which is as
okay,
it
well,
should
I
be.
can't see me, so I'm assuming that I haven't got my glasses on upside down or anything. So good evening. Successfully navigating a sale. I'll go through the basic principles of the legal aspects of selling a practice. First of all, just a little bit about, hang on, why isn't it changing slide? There we go. Personal introduction. So my name's Ray Goodman. I've been a specialist dental lawyer for over 30 years. It's hard to believe. And I'm a partner in Acuity Law, who are a full-service corporate law firm. I'm a partner in the dental team. Previously, up to about 2.5 years ago, I was one of the partners in Goodman Grant. We were a boutique specialist law firm dealing almost exclusively with the business of dentists. We don't sue dentists. We only look after them, and we deal with anything in the anything to do with the business of dentistry. So most of our work relates to practice transfers, buying and selling practices. We completed £60 million worth of transactions in the 3 months up to the 31st of March. I'm a member of the ASPD, and in fact, today is the annual ASPD conference. So I'm talking to you from my hotel bedroom in Bristol, while the rest of them are sailing around Bristol Harbour on a boat with a bar. I'm here talking to you. So, and it's my pleasure to do so. I was the chairman of the NASDAL Lawyers Group, still members of NASDAL. We were on the BDA recommended panel of specialist dental lawyers, although they no longer, for political reasons, I think, no longer have lists. But when they did, we were on it. And we have offices in London, Liverpool, Cardiff, Bristol, Swansea, Birmingham, and Leeds. So we cover the whole country and advise on anything to do with the business of dentistry. So that's my background. Whoops, wrong way. So the first step, what can you do to prepare for sale? First question would always be, are your accounts up to date? It's surprising how often people don't have their accounts up to date. Either the stuff's still on your computer and hasn't been sent over to your accountant, or if you're not that computer savvy, all your receipts and vouchers are in a box somewhere. Get them over to your accountant, and if your accountant has got all the information but is being a bit slow over getting your accounts prepared, if you're looking to sell, any buyer is going to want to see your accounts. And Andy and his team are going to ask if your accounts, in order to enable them to do a valuation, because a big part of any valuation is the EBITDA, the earnings before interest, tax, depreciation, and amortization, which is information that you'll need from your accounts. Also, also very useful, and I'm sure Andy and his team will advise you on this if you're instructing them to value your practice. How do you compare against benchmarks? If you look at the benchmarks and find that you're paying 10-20% more for your materials, if you're overpaying your associates or therapists or hygienists, you may be able to take some action. It's remarkable, sometimes we look at practices and say, well, hang on a minute, if you reduced what you're spending on this and what you're spending on that, or restructure the way you're paying your therapists or hygienists, you could add 30,000-40,000 pounds on your bottom line in 12 months time. If you're looking at selling at a multiple of EBITDA of, say, 7, and you've saved 40,000 pounds, that's another 280,000 pounds on your practice valuation. So speak to Andy and his team about that, because they're the guys who can steer you in the right direction. The other thing is, we're going to come on in a minute to talk about due diligence. Have you got all your documents to hand? Have you got all your compliance documents? Copies of things like your insurance policies, pressure vessel and X-ray test certificates, because during the due diligence process, your buyer is going to want to look at those. If you any practice sale is going to involve some element of property. Either you're going to sell the freehold that you own, or you're going to assign an existing lease that you have, or grant a new lease. If you've got an existing leasehold property, most buyers will require at least 10 years and often 15 years left to run on the lease, because that's what the lenders will require to see. If you've only got a few years left on a lease, it's well worth contacting your landlord at the earliest opportunity to ask them if they would be prepared to extend the term to 10 or 15 years. In most cases, it won't be a problem. They'll be delighted because it actually increases the value of the freehold interest. But landlords and their solicitors often don't work very quickly in these scenarios because they don't really have any skin in the game. It doesn't really make any difference to them. So it can be something that slows things down. So again, if you're looking to sell and you've got a small, 4, 5, 6, 7, 8, less than 10 years, certainly, to run on your lease, worth making that inquiry of the landlord's agent, or if you deal directly with the landlord. Other things that you should check are up to date: contracts of employment, associates agreements. There has been quite a lot of movement in the area of employment law, questions as to whether associates are actually self-employed or not, whether they would be deemed to be workers even if they are self-employed, which can entitle them to holiday pay and maternity and paternity pay. Might be worth having a conversation with your solicitors just to check that they're all up to date. We can look at those for you if you want. The sooner these things are looked at, and if any changes are needed, then the better, because it's less likely to slow things down. So first stage of any transaction is likely to be heads of terms. So what are heads of terms? Well, heads of terms are essentially, well, sometimes they're called letters of intent, heads of agreement, but they're a non-binding document that sets out the basic terms that you've agreed between you. So the price, any time limits, what you're actually buying, the structure of a deal. Is it if it's a limited company, is it to be a share sale or an asset sale? The basic terms of the deal. Are they essential? No, there's no legal requirement to have heads of terms. But in the majority of cases, particularly if you're using a specialist agent, the agent will prepare heads of terms. Up until a year or two ago, they were getting more and more complicated, and in particular in relation to the terms of any deposits that buyers were required to pay to agents, quite complex. And often the lawyers ended up getting involved in negotiating the heads of terms. I'm pleased to say that over the last few years, and I know Frank Tellers have always been quite sensible and kept their heads of terms quite brief and sensible, and even more so now, that they're much more brief. And they only deal with the basic terms. And they're useful in that, firstly, it makes sure that everybody is agreed and that we're all going down the same road, because it would be a shame to spend time and money going down the road and then finding after a few weeks or months and hundreds if not thousands of pounds of costs that actually you're not all on the same page. So it ensures everybody's on the same page. Are they legally enforceable? In general terms, no. However, there will usually be one or two terms which are specifically expressed to be and are therefore legally enforceable. Usually the provisions regarding exclusivity. So once you've agreed terms with your buyer, the likelihood is that the buyer will pay a deposit and you will agree that they can have a period of months in which to proceed with the transaction and to complete. That's to protect both of you, so that the buyer isn't just paying money and then you go off and decide to negotiate with somebody else, and also to protect you, that there is a deposit payable and there are terms set out in the heads of terms by your agent to deal with who receives those under what circumstances. They're generally prepared by the agents. And as I've said, they don't bind you to complete. Parties are not bound to complete until there's an unconditional exchange of contracts. Now, In most transactions these days, we don't have a separate exchange of contracts and completion. Where we have a practice with an NHS contract, it's more likely, because we have to give notice to the LAT of 28 days before we can complete. So there's likely to be a conditional exchange, conditional upon the NHS amending the NHS contract after being served notice. But we'll come on to that a bit more in a few minutes' time. So that's heads of terms, not generally legally binding, but useful to deal with fundamental terms so that we all know that we're on the same page, and also prevents argument further down the line. Certain fundamental points can be dealt with in the heads of terms, saves time, saves money in terms of professional fees. So the next thing we're going to talk about is due diligence. And you need to be prepared to answer a lot of questions. It's not generally as threatening as the picture that I put there, but I'm sure the point's well made. So due diligence is a comprehensive appraisal of a business undertaken by a prospective buyer, especially to establish its assets and liabilities and evaluate its commercial potential. So your buyer, or his advisors more particularly, are going to want to check things like compliance and other aspects of the business to make sure that the buyer knows what he's buying and can identify any latent or patent problems. And if problems do come up in due diligence, they can be dealt with. If, for example, one of the due diligence questions is, please produce a copy of your pressure vessel test certificate, and it's out of date, then it's something that can be dealt with in the course of the transaction. Either the buyer can say, well, we want you to get an up-to-date test certificate, or you could say, well, he needs a new test certificate. It's going to cost £400, so we want an allowance of £400. But it brings things to the surface and enables them to be dealt with. There's three main areas: financial, as we mentioned before. Clearly, the buyer's accountant is going to want to look at your accounts, probably at least the last 3 years' accounts, and potentially they may want even more, because of course we've got the COVID period when things were far from typical. Property, every practice will have some element of property. There is a standard form called the Commercial Property Standard Inquiries, which every buyer solicitor will send to you. This was something that was produced by the British Property Federation about 15 years ago, supposedly to simplify commercial property transactions, but like everything else that's been produced by a committee, a quango, they just made it more complicated, and they're couched in some fairly complicated legal gobbledygook. Where if we're acting, we normally send a crib sheet out to our clients, which give typical answers, although of course you have to make sure that they are correct in the circumstances. And commercial. So the commercial due diligence will be things like a lot of compliance questions, asking for copies of contracts, staff contracts, confirmation that there's no complaints, that there's no insurance claims, anything to do with the commercial operation of the practice. Now, it can be a lot of work. Our due diligence questionnaire is about 20 pages long, but it's information that you will have. And particularly since CQC registration came in, you have to have all the compliance stuff. So you will have it. If you were bringing your practice manager into the loop of your sale, then often it's much easier to get your practice manager to do it. If you don't want to bring your practice manager or somebody else into your confidence whilst the sale is proceeding, then it's the sort of stuff that you may have to go in over the weekend or after hours and get stuff out of the cabinets. Where we're acting for a seller, we will Well, first of all, we'd be happy to send you our due diligence questionnaire right at the beginning so that you can start preparing and getting all the information that you're going to need handy. And we then set up a confidential data room on the internet, and you can simply scan all the documents into our data room. We'll then collate them and index them and send them over to the buyer's solicitors and grant them access to the data room. So it makes it as easy as easy as it can be. It is work that only you can do. That's the only part of the process that we can't do for you, because it's information that is purely in your possession. So following the due diligence, we then get involved in the actual sale and purchase agreement itself. Now, this is the main document. It sets out in full the terms of the agreement, price, timings, obligations of the parties, who's got to do what by when. And importantly, it will include a schedule of warranties. Now, a warranty is a contractual statement made by you as the seller to the buyer, which, if it's untrue and the buyer suffers loss, they can claim that loss from you. So, for example, if you were to give a warranty that there are no employment, well, actually, that's probably not the best example, that there are no insurance claims against the practice, and the practice has never been penalized for a claims history and has never been charged increased premium. And it turns out that that's not correct. And as a result, the buyer has to pay an extra £10,000 a year premium going forward on their insurance. Then that is potentially a warranty claim. The other important list, which is similar but subtly different in terms of statements, are indemnities, which are promises by the seller to the buyer relating to specific costs or losses if certain events occur. Now, unlike warranties, an indemnity provides a right to compensation without the buyer having to prove a loss. And they tend to be in relation to specific risk that is identifiable as a risk. For example, the seller will indemnify the buyer against any claims for unpaid tax, or the seller will indemnify the buyer against any claims for breaches of employment law in the period up until completion of the sale. These are things that are liabilities that you would have if you were still there, and they've been incurred during the period of your ownership, so it's not unreasonable that you indemnify them. Now, people start getting worried when we talk about pages and pages of warranties. There's no need to be. They have to be taken seriously. We, as your lawyers, would always seek to mitigate any warranties to make sure that they are not warranting anything which is too general, which we can't know is true or false. And we will build in for you a schedule of seller protection provisions. Now, one of the main ones of those is that we would say that the warranties are true and correct, save as disclosed in the disclosure letter, which is a formal document that we prepare on your behalf prior to completion or prior to exchange, in which preparation for which we would go through all the warranties and indemnities, and you would tell us if any of them are in any respect not absolutely true. And to the extent that we therefore disclose anything that's not true, that disclosure is carved out of the risk. So, using the example we just used, if we've said, if the warranty says there have been no claims on the practice's public liability insurance, and actually there had been, we would leave the disclosure as it was, and then we would put in the disclosure letter that the seller has received a claim from patient X who claims to have tripped over a mat in the reception area. This is being dealt with by the insurers, who believe that there is that liability will not be established, or words to that effect. It's up to us to disclose as much as possible. If we have, then the buyer knows about that, and that risk is carved out of any risk under the warranties. There'll be other limitations. There would be an individual de minimis provision. So we would normally say you would not be liable for any breaches of warranty where the value is less than £1,000. So you're not having to worry if one of the hand pieces isn't working properly, or something which is relatively of small value. It doesn't count. And then we would negotiate a larger de minimis, generally known as a basket de minimis. So first of all, nothing under £1,000 counts. Anything over £1,000 won't count until it exceeds the basket de minimis, which would generally be, depending on the size of the deal, anything between £10,000 and £20,000. Depends on the deal, and it depends on how good your lawyers are in negotiating what is a reasonable de minimis. And there would be a time limit for enforcement of warranty claims, because certainly you don't want to have the risk of a warranty claim hanging over you for any period longer than is necessary. We would normally, acting for a seller, look to limit it to a 12-month period. That might be a bit optimistic. If I was acting for the buyer, I would be looking for a 2-year period, and probably we would end up in both cases settling on a period of about 18 months. But it's, each deal it stands on its own and is subject to a negotiation. If you have an incorporated practice, i.e. it's a limited company, you won't be selling the practice. Well, it would be unlikely. In the vast majority of transactions where the practice is incorporated, it's far more tax effective for you to sell your shares in the limited company rather than the assets of the practice, which is what you would be selling if you're in sole practitioner or in a partnership and you own the assets yourself. Because it's a limited company, any liabilities that the company has remain unchanged, irrespective of the change of shareholder. The practice is still owned by the limited company. The limited company is not affected by the change of shareholder. All that's happening is that you are selling ownership of the shares in the company that owns the practice. So because of that, any liabilities that the company has, for example, tax, will continue unchanged, irrespective of the change of ownership. So your buyer is going to understandably want protection from that. We talked about indemnities before. One of the main indemnities would be an indemnity for all tax that arises as a result of the activity of the company up to the date of completion. So if you have underdeclared or underpaid tax on the company in years up until the date of completion, and that comes to light after completion, the deed of tax indemnity is about 12 pages of real legal gobbledygook, but essentially what it says is you will be responsible, the seller will be responsible for indemnifying the buyer against any tax relating to the period up until completion. On a share sale, the sale agreement is likely also to have provisions dealing with how we calculate the net assets and adjust the price if net assets are in the negative. So because it's a limited company, it's impossible to know the financial position of that company as at the date of completion. There could be monies paid into the bank that haven't cleared, monies paid out which haven't yet cleared, all sorts of things. It's impossible to know the financial position of a limited company without doing a set of accounts. And obviously, it's not possible to prepare a set of accounts on the day of completion. So the agreement would normally say within 60 days your accountant will prepare a set of accounts, and we provide in the sale and purchase agreement the basis upon which those accounts are to be prepared to make sure that they are fair and reasonable, and those terms are agreed by both parties. We would always send them to your own accountants to confirm that they're happy that we've covered the basis of all of the various valuations within the accounts, and that there's and also that they're happy with the deed of tax indemnity. And finally, it will deal with anything to be dealt with post-completion. For example, if it's an NHS practice, you as seller will need to give notice to dissolve the partnership that we may have created to enable you to transfer the contract within so many weeks of completion, and that would be a post-completion obligation. And again, we'll come on to that a bit further in the next slide. So the sale agreement is a very comprehensive agreement that sets out all of the terms in detail, because the sale and purchase agreement will say that apart from the replies to the due diligence, which you will be warranting are correct, nothing else, that no other information that you may have given or somebody may have given on your behalf to the buyer is warranted unless it's in the sale and purchase agreement. So that is the definitive agreement that sets out all the terms and provides for the rights and obligations of the parties. Now, NHS practices are slightly different because NHS contracts are non-transferable. Clause 12 of the GDS contract says that you cannot assign the benefit of the contract. So the starting point is that you can't actually sell it. Now, obviously, if that were the case, I wouldn't have been buying and selling NHS practices on a daily basis since the new contract in 2006. So what we do is this. Although the contract cannot be assigned, it's a breach of the contract, you can, under clause 227, I think, of the GDS regulations or the GDS contract, by giving not less than 28 days notice to the LAT, give notice that you require the contract to be varied to add a partner or partners. So once we've negotiated all the other terms of the head of the sale and purchase agreement, we give notice to the NHS in a prescribed form that's in the regulations to say that the buyer, the seller wants to add the buyer as a contractor. NHS then has 28 days to add to issue a variation to add the partner or the buyer or buyers. Once that's done, we can complete the sale, and you enter into a deed of partnership with the sellers, with the buyer, but the buyer owns 99.9999% of the contract. You retain a notional 0.0001% with a value of £1. So technically there's a partnership. I've only known a handful of times when somebody tries to be clever from the LAT and says, we don't believe that this is a true partnership and we think you're trying to get around the regulations. And on each of those occasions, when they've received my 30-page partnership agreement, which would be part of your suite of documents that we draft, as soon as that lands on the LAT official's desk, then they say, okay, yeah, it's a partnership, and they don't even read it. And we redact any financial details, so they don't know what the percentage is that you're holding and that it's only effectively a notional amount, because frankly, it's none of their business. So that's how it works. In order that you can give the notice to the LAT, the practice will have to have a partnership registration. So if you are an individual or a partnership and you are looking to transfer your contract using the partnership route, one of the first things that needs to happen is both you and your buyer or buyers will need to apply to the CQC for a partnership registration. We can do that for you if you instruct Acuity Law. Some people like to do it themselves or have CQC consultants, but we do have a CQC team. We also sometimes do it for the buyer because it's helpful to coordinate the buyers and the sellers application. And of course, before you can do that, the very first thing that you need to do once you're moving down the sale process, and Andy and his team will advise you about this, is that you and the buyer will both need up-to-date enhanced DBS checks. So finally, with the NHS process, once you've completed, a few weeks later, we serve notice of retirement of you as the seller, which basically says, "Dear NHS, I, Dr. Seller, and Dr. Buyer, we, Dr. Seller and Dr. Buyer, have decided that Dr. Seller now wishes to retire from the contract. Please amend," and then there has to be another variation, which takes you off. In the interim period, in the partnership agreement that deals with this notional partnership, there is an indemnity indemnifying you against any claims under the contract. The risk is very small, but it's covered off by the indemnity, and generally we would serve the notice of retirement a respectable period after completion. We don't want to do it the next day, because that really is kicking sand in the face of the LAT. So we wait about 6 weeks. We've been doing this since 2006. At first, when we first started doing the partnership route, we were just waiting for an LAT to challenge it and say, "This is a sham, you can't do this." The reality is, we're almost 20 years, well, 19 years down the line now. They all know that this is the way that contracts are transferred. And it's just a sort of accepted thing. And it works. I love this slide because I think it really sums up anything that, any message that we're trying to pass on to you today. You're very fortunate as a profession. I mean, as I mentioned before, I'm actually here in Bristol at the annual conference and dinner of the Association of Specialist Providers for Dentists, which is, there's a handful of lawyers here, a couple of agents, IFAs that are specialists, funders, banks. There's a whole raft of specialist professionals who are highly skilled in dealing with your specialist niche businesses, because the rules about dentistry are not something, well, certainly it's not something that you learn in law school. I've been dealing with dental practices for over 30 years. It is very specialist. Often we still find that we're dealing with lawyers who've been instructed by one of the parties, who are it's the guy they play golf with, the guy that did their divorce. They say, "Oh, I'm selling my practice. Can you do it for me? How much?" And they think, "Oh yeah, it's a house with a few cupboards in it." They wouldn't know a UDA if they fell over it in the street. They have no idea of the complexity of the compliance regime, don't know the questions to ask. And when they receive, if they're buying and they receive from me a 60-page document with partnership agreements and draft notices to the LAT, they're like rabbits in the headlights. And what tends to happen is not very much for a very long time, because they just don't know. So if you take one thing away from this, it is use specialist advisors. You've got people like Andy and his team at Frank Taylor Associates, hugely experienced in valuing and marketing and selling dental practices. We in Acuity Law, well, I've done over the 30 plus years, hundreds, if not thousands, of dental practice transactions. We, in the rush up to 31st of March, we completed at Acuity £60 million worth of transactions in the 3 months up to the 31st of March. It's always busy coming up to the 31st of March because obviously it's the end of the tax year, it's the end of the LAT contract year. It's a very convenient point to sell. It doesn't mean it makes it any more difficult to sell at any other point, but it just seems to be that people always want to complete on that date. If you are looking to sell in the next 12 months, I would strongly advise that you get Andy and his team at FTA to start marketing now, because you've got the time involved in finding a buyer. And then transactions are taking on average 6 to 7 months, depending on the deal. Some deals will be quicker. It can be quicker if you're selling to a corporate, because they don't have to go off and find, and talk to a bank and get funding. They generally have, much bigger funding facilities. So there isn't a delay there. But if you're thinking of wanting to complete on or before the 31st of March 2026, now's the time to start getting your practice on the market and getting your ducks in a row. So I think that is a very brief and whistle-stop tour of the elements of of the sale of a dental practice. Happy to take any questions or from any of you, or Andy, if you've got anything, if you think there's anything that I've missed that people might like to hear about, I'm all ears.
Cheers for that, Ray. That was great. It's funny, I've heard you talk on a number of occasions, and I always feel there's something extra in there that either reminds me on a point that perhaps we gloss over, or it's like, actually, that's a really interesting thing, because things do change, and I'm sure you've seen it in your 19 years since what we still call the new NHS contract came in 2006. Just that evolution of how to navigate LATs, and they've gone through different iterations. So every time there's a change there, I'm sure you have to adapt your strategy in terms of how you approach it.
Yeah, absolutely. And of course, we didn't have, back in 2006, we didn't have the Health and Social Care Act, so we didn't have the extra level bureaucracy with the CQC, which, as you know, Andy, tends to be one of the main factors that delays things.
Yeah.
Now, we've just been discussing the situation with CQC, along with lots of other things with the ASPD, and the general consensus is that they have speeded up a bit. It's not as bad as it was.
Yeah, it was 16 weeks for a long while, wasn't it?
I mean, post-COVID, it was just awful. It was 5 or 6 months, because they had all the post-COVID backlog of stuff to deal with. But they have got better.
Just on the DD side of things, Ray, for people that are selling, and I'm making an assumption here that people have joined us this evening because either they're toying with the idea of selling, or they're going to be going to that process in the next 6, 9, 12, 18 months, something in that order. When's a good time to start? I said at the beginning that I genuinely believe it's the seller who has the most control over the timeline of their transaction. And typically what happens is sellers come to a guy like me, we value it, we put it to the market, we find them a buyer, the offer gets accepted. At that point, they tend to start the due diligence, because that's when they start talking to a solicitor. Is there merit in getting from somebody like yourself what the due diligence guide is? What do they need to prepare? And start filling, a flash drive, a carrier bag, a folder, whatever it is, with that key documentation in readiness. So once they've got their buyer, they're ready to go.
Yeah, absolutely. As I mentioned earlier, if somebody wants to instruct us, we're happy when we send out the initial compliance stuff that we're obliged by law to send before we can do any work. Happy to send our due diligence questionnaire that we would be using if we were acting for a buyer. Happy to send it to our seller clients as an example. I don't think anybody else's is going to be more comprehensive than ours. So if you went through ours, it shows you the information that you're going to need, gives you time to start putting it all together, identifying things that might be missing. Oh, where's my pressure vessel test certificate?
Yeah.
Where's my NHS contract? Because lots of people sign the contract, under protest in 2006, threw it in a drawer somewhere and haven't looked at it since.
I think also what it enables, if people do that, there's obviously a sensitivity and confidentiality around selling your practice. So if you can start assembling that paperwork and documentation over the weeks, if not months before you sell, you can do an hour here and an hour there. It fits in your daily workflow. It doesn't stand out. Your behavior doesn't change. Suddenly you're not staying back at the practice every night of the week. Suddenly you're not finding reasons to go out of a weekend. And quite often people notice those subtle changes in behavior. So I think it could also help with preserving confidentiality, which is good. We've got another question coming, Ray. What are the rules with CQC if you are a limited company?
Well, okay, there are various aspects of that. If the NHS, right, okay, let's take the example of a limited company that doesn't have an NHS contract for a moment. I'll come back to where it does. The limited company, as I said before, is a separate person in law. So the registration should be in the name of the limited company. So it's the company that will be registered. Now, there are many practices that I've come across and continue to come across where it's not quite as it should be. And some people still have the registration in their individual name. In some cases, as you well know, Andy, they've got the NHS contract is retained in an individual or partnership, and the private work is in a limited company.
If you've ever heard the phrase of flawed incorporation, Ray's giving you examples of what would be a flawed incorporation. It wasn't done properly.
Yeah, well, possibly, but not necessarily, because there are ways of doing it to keep the contract out that aren't flawed.
Yes,
but yeah, that's a whole different seminar, really. So the limited company, assuming that the registration is correct, it's the company that's registered. All you'll be doing is all you'll need to do is appoint a new registered manager and notify the CQC of a change of control. So you won't be making a fresh application in the majority of cases. Now, if there's an NHS contract and it's held in the company, you're not transferring the contract because it's owned by the company and it continues to be owned by the company. So we don't have this smoke and mirrors thing of creating partnerships and dissolving them again and registering for a CQC partnership and then dissolving it and the whole, all that smoke and mirrors. So that's relatively straightforward. If, as is the case in quite a number of practices, particularly where somebody's bought a practice as an individual with an NHS contract, which has been transferred by the partnership group and then incorporated and hasn't incorporated the NHS contract, or perhaps the LAT has not agreed to the incorporation of the contract, so that remains outside the company in the name of one or more individuals, then technically there should be two registrations. I've seen in the majority of situations where that is the case, it's wrong, and they only have the company registered or the individuals. There should actually be two separate registrations there. In any event, you would need, if the contract's in the name of the individuals, then you would still need to do the same as you would be doing if it was an asset sale, in creating a partnership with the buyer and transferring the contract to the buyer, because the buyer will have to hold it outside of the limited company in the same way that it currently is. They could always then subcontract the performance of the UDAs to the limited company. That's one way of having it outside the company, but not a flawed incorporation. Or they could apply after completion to the NHS and see if they'll agree to them transferring the contract to the company. So it depends on the structure, is the short answer, and as to whether there's an NHS contract, what the current registration is. But if it's just a limited company, then it's a relatively straightforward process, because it's just notification of change of control and appointment of a new registered manager.
Brilliant. On property in particular, if it's a freehold, obviously the person who owns a practice owns a building, whether they're selling the property or whether they're keeping the property, they still have control in they're the decision maker. So they either sell the freehold to the person who's buying the practice, or they can retain the freehold, create a lease. Where they operate from a leasehold, so they have a third-party landlord, are there things that the practice owner can do early on to make sure that they're in good shape? Because it's not common, but there can be instances where third-party landlords don't move particularly quickly. And is there any prep work that people can do if they're operating from a leasehold?
Yeah, absolutely. I mean, as I said earlier on, if you've only got a relatively small lease, or a relatively short period left to run on your lease, and by that, anything less than 10 years, you're likely to be asked to ask the landlord to extend the lease. And as you say, Andy, landlords have got no skin in the game. And whilst it might be in their interest to grant a new longer term, they're not in any rush. Neither are their lawyers. So the sooner you can get that moving, the better. And even if you're not quite ready to start marketing it, certainly make the inquiry of your landlord, either through their managing agents, or if you deal directly with them, through them, as to whether or not they would be prepared either to grant a new lease if you're selling it, or to extend the lease and then you can assign the lease. Sometimes they'll say, well, we'll accept a surrender from you and we'll grant the tenant a new lease, which actually is a better scenario for the seller if you can do that, because it removes any residual liability you may have. Most commercial leases have a provision whereby on the first assignment, so if you've taken an original lease, when you come to assign that, the landlord can often require you to enter into a guarantee, which guarantees performance of payment of the rent and the other covenants by the person buying it off. If you can proceed without that and just get the landlord to accept a surrender of your lease and grant a new one simultaneously to the buyer, that's a better situation for you as seller.
Sure. And if you operate as a limited company, accountants would normally advise that you sell the limited company in totality. So you sell the shares in that limited company. From a legal perspective, is there any merit and benefit either way in terms of just selling the assets out of the company, retaining the holding, or selling as a share?
It's not so much a legal benefit, it's a tax benefit, because if you're selling, if you've got a practice in a limited company and for whatever reason you sell the assets, it's the company that's the seller, because the company owns the assets. So the purchase price is going to go to the company, who is then going to pay capital gains tax on it. You've then got the money inside the limited company, but you as the owner of the company will want to take it out. And there's a potential second tax charge then when you withdraw the money out of the company. So generally, it's almost always beneficial to sell the shares, because it's then you as the individual selling those shares. You're the one that's making the capital gain. You'll have your tax allowances, but you're avoiding this double tax scenario. There are other issues regarding tax, and I don't want to go in too much detail here, but if you've got an incorporated practice and you've got significant sums of cash sitting in the bank, there are things that we can do to make the withdrawal of that cash far more tax effective than just drawing it out as dividends or bonuses or salaries. To cut a long story short, and again, I could do a whole seminar just on this, we can create a structure whereby you leave that money in. So, for example, if you've got £200,000 of cash sitting in your bank account, rather than drawing it out and paying tax at 40+%, we can leave it in and sell that cash to the buyer. So add that £200,000 to your purchase price, get the buyer to pay you that £200,000. So buying the cash of £200,000 for £200,000, it then becomes a capital sum rather than an income sum, and you're paying tax at CGT rates rather than income rates. Now, it has to be done properly, and it depends on the circumstances, and sometimes we have to put in complex scenarios whereby we lend it to the sellers. So we lend it to the buyers, and it gets held by the buyer solicitors, and we make sure it's watertight and held under very tight solicitors' undertakings for 24 hours, and then they give it back to us. So it's not that straightforward, but if you've got solicitors who are sector specialists and know what they're doing, that's one of the things you can do, again, to save considerable tax.
I think that one tip there, Ray, is enough to compel using somebody that understands the market, because just the tax difference of if you did take it out as salary and dividend, as opposed to it being treated at the tax rates on disposal, capital gains tax rates, that would more than outweigh the reason to understand what they're, to take somebody on who knows what they're doing.
Absolutely.
Ray, thank you very much indeed. That was great. You covered a lot of ground there, and it's probably a lot of food for thought for people. And I think the overriding thing is get specialist advice and start sooner than you think, because there is work to be done. I think if you do those two things, that's a great learning. Yeah,
absolutely, Andy. And I'm always happy to have a chat with anybody. If anybody's got any questions, just give me a call. Yeah.
Brilliant.
You've got the details on the screen there, or you can just Google me on, or through FTA. Always happy to help.
Beautiful, lovely. We'll let you go, Ray. Hopefully, the boat has returned with your fellow members from your meeting today, and you might be able to catch them for a late drink.
I think there'll be many ahead of me, so God knows what I'm going to find when I get down there. But
brilliant,
it should
lovely.
Be
well, thank you very much.
Enjoy the rest of the evening. Thank you, everybody, for joining, and see you soon.
Thank you very much indeed. Thank you all. Cheers.